the hearing to order. Today's hearing addresses an important topic, a topic that I think is becoming increasingly important. Unlocking innovation and new entry into the marketplace by reducing anti-competitive government regulations. Regulations that in many instances secure the position of market incumbents to the exclusion of would-be competitors. Far too often, federal regulations, even those that are there, that are intended to protect the American public in one way or another, in many circumstances, they end up creating a whipsaw effect and having some really ugly consequences because they end up insulating businesses from competition. One thing we understand about competition is that it tends to bring prices down and it tends to improve quality when competition is present. But to the degree that competition is not present, the opposite tends to happen. So when regulations require expensive compliance costs that only large incumbents have the meaningful ability to comply with while remaining competitive, regulations become monopoly moats rather than consumer protections. The economic cost is enormous. Now, just last year, just new federal regulations, major rules promulgated by executive branch agencies put into law without any subsequent additional vote by Congress or presentment to the president for signature, veto, or acquiescence, added a record $1.5 trillion in new regulatory compliance costs, just the regs put in place in 2024 alone. Now, that doesn't include the previous regulations, which have been estimated, including last year's regulations, at somewhere in the 3 to 4, some would say more $trillion every single year. This starts to rival what Americans pay in their federal taxes. This is a huge draw on the economy, and it ends up disproportionately inuring to the detriment of America's poor and middle class. This also doesn't include the innovations that never happened, the businesses that were never launched, and the competitive pressure that never materialized so as to bring quality up and prices down. President Trump has recognized this issue and in April issued an executive order directing the federal government under his administration to identify regulations that hold back American businesses and stifle competition, thus ultimately harming consumers. The response has been remarkable, and with organizations across the country, across every major economic sector, submitting detailed comments about regulatory barriers that tend to increase compliance costs, that tend to limit innovation, and ultimately harm the consumers, the very consumers in many instances that they're supposed to help. I want to thank, among others, our members of our Federal Trade Commission, one of whom we'll hear from in a few minutes and who I'll introduce shortly, FTC Chair Andrew Ferguson and Assistant Attorney General Slater, for their leadership in prioritizing this issue and for sending witnesses from the Federal Trade Commission and from the Department of Justice's Antitrust Division to highlight their findings. Deregulation tends to level the playing field by removing barriers that stifle free market dynamics. In such an environment, competition policy flourishes as firms are incentivized to innovate rather than being hindered. I've introduced a number of bills over the years that deal with this issue one way or another. I'd like to briefly describe 3 of those to give you sort of a cross-section of some of the approaches that we can take in this area. First, the OFF Act, Opportunities for Fairness in Farming. A piece of legislation I'm very proud of, and that's been co-sponsored by my ranking member, Senator Booker from New Jersey, would reform the mandatory farmer assessment programs existing under federal law. The Got Milk campaign or the Beef It's What for Dinner campaign. These are the kinds of things that are funded by these mandatory assessments to our farmers. Unfortunately, some programs have awarded unauthorized bonuses. For example, a USDA investigation found that one organization had used checkoff funds for $300,000 in bonuses and then asked for more funds to fix their financial situation. The checkoff programs are all too often used by the largest players. The largest players in the checkoff program, in the industry itself, in order to entrench their position while severely undermining the interests of independent producers, many of which tend to operate with much narrower margins already. And so that the expense added by the checkoff payments, which are mandatory, have the effect of a tax, end up disproportionately affecting them, and quite adversely. This bipartisan legislation would require transparent financial reporting. It would ban conflicts of interest and mandate regular audits in this area. Second, the Open America's Waters Act would repeal the so-called Jones Act, more than a century-old federal restriction that's created something of a shipping monopoly, or at least a distortion in the marketplace that ends up costing American consumers, in some parts of the country more than others. Our domestic cargo fleet has, during the a little more than a century since that was enacted, shrunk to 92 ships, half of what we had in 2000. In 2023, American shipyards built only 5 large vessels, while China built 1,749. This artificial scarcity forces all of us to pay inflated shipping costs, especially people in certain parts of the country. Americans living in Alaska, in Hawaii, in Puerto Rico, Guam, and parts of New England suffer disproportionately for this. So to the extent this is going to be a policy, we need to at least take into account that it's a policy with enormous costs that affects different Americans quite differently, and some very severely, depending on where they live. The Jones Act's restrictions are so onerous that they even apply in many instances to transporting disaster relief supplies. The result is watching relief cargo sit idle while Americans suffer after natural disasters. The Open America Waters Act would unlock competition, reduce shipping costs, and allow consumers to receive goods faster. Third, the Biosimilar Red Tape Elimination Act tackles artificial barriers in our healthcare system. When developing biosimilar drugs, which tend to be very expensive in the world of pharmaceuticals, companies face unnecessary regulatory hurdles that keep cheaper alternatives to the original branded product off the market. This bill would streamline the approval process by automatically deeming all approved biosimilars as interchangeable with their brand name counterparts. This would eliminate a significant amount of redundant switching costs and switching studies that pharmaceutical companies use in order to delay competition and align regulation with current scientific reality. In each case, and in the case of other reform legislation in this area, these bills remove needless government regulations. They would save billions of dollars, and they'd empower businesses to innovate, to compete, and deliver value to the American consumers. So let us continue to champion smart regulation for a prosperous America. I want to thank our witnesses for joining us today, and look forward to introducing them in a few minutes and hearing their perspectives. In the meantime, let's turn it over to Ranking Member Senator Booker.
I'm really grateful to our chairperson for convening this hearing in partnership with us, and for so many of the areas in which we overlap. I want to note that one of the true great leaders on issues of antitrust is here next to me, is Amy Klobuchar, who I know is under a lot of demand, as is Senator Blumenthal. There's a lot going on in the Senate today. I want to thank the witnesses for being here. It means a lot that you all would take time to come and give testimony in this important hearing. And I want to thank, obviously, you can see packed room, standing room only. I want to definitely thank the purple shirts here. I can recognize SEIU brothers and sisters when I see them. So thank you all for being here. Something that I know Mike Lee and I agree on is just this concept of liberty in the United States, this idea of freedom. And part of that idea, part of those conceptions, is the idea of economic liberty as well, that powerful anti-competitive forces won't undermine the benefits you get from having liberty and the deals and opportunities for people to enter into the marketplace in a competitive fashion that expands the sense of the reality of opportunity for everybody. I'm a big believer that personal liberty is directly tied to economic liberty. These two freedoms should not be restricted to some. by people who violate some of those laws of liberty. Throughout my time as a senator and before, I've worked to fight to make sure that all families and all workers really are able to access that liberty and not just the powerful, whether it's powerful political lobbies or powerful concentrations of economic power. When we talk about a competitive economy, what we're really talking about is ensuring that everyone has fair opportunities and a level playing field, that every entrepreneur making products people need or want has things like access to capital to start their first business, that every small business has tools to compete fairly against even the dominant players, that workers can switch jobs without being held back by non-compete or non-poach agreements between employers that undermines the power of labor. The rules are rigged in a society when monopolies prevent new entrants into a given industry, such as dominant mega stores that make it almost impossible for mom and pop grocery stores to stay afloat. The rules are rigged when vertical integration is allowed and the largest health groups own both the insurance company, the pharmacy benefit manager, the pharmacy, and employs all the doctors. The rules are rigged when some of the country's wealthiest business people can dominate marketplaces by perverting rules, by donating millions of dollars to politicians. I believe watching the president's inauguration get millions and millions of dollars from people that were looking to abuse the system, and people who were not donating watch them get political favors. I believe the rules are rigged when the biggest players refuse to play fair and all the rest of us are the ones that lose. We're going to hear testimony today about the current state of the beef market in our country. It's something I focused a lot on, about how a lack of regulation combined with failing to enforce our antitrust laws has led over the past 3 decades to the top 4 beef packers expanding their market share from 32% to over 80%, and the devastating impact that's had on independent family farmers and ranchers, not to mention consumers. I've seen this devastation firsthand. I was just talking to one of our witnesses about several years ago. I went across this country to meet with farmers and ranchers and hear story after story about how the lack of competition was making it impossible for them to make ends meet. I'll never forget one rancher in Kansas when I was sitting at his kitchen table, how he told me about how his farm had been in his family for 5 generations, generation after generation, making it work. Hard work, hard scrabble, difficult work, but they were able to make a living and make a great life. I loved when he showed me the framed land grant on his wall when his great-great-grandfather acquired the land. But he was afraid that he would be the first one not to be able to pass the farm on to his children because of anti-competitive, unfair practices. He told me about how 30 years ago he used to have dozens of potential buyers for his cattle. But today he had just one buyer who didn't offer him a fair price. He didn't want me to take pictures. Now, we talk about fear. He didn't want me to take any pictures while I was there because he was afraid that if his one buyer even found out that he had been talking to me, a policymaker, that he might get cut off. This is not fair. This is not right. If we want to ensure we have a competitive economy, we cannot restrict ourselves. Allow such anti-competitive actions to begin. Now look, I'm a former mayor. I've seen bad government regulations have unintended consequences and hurt people. But I don't believe that regulations are bad in and of themselves. It is wonderful when regulations actually achieve their goals and promote competition. But the primary focus when rulemakers are promulgating regulations is to make sure they're effective in the congressional intent. When promulgating rules, the first thought of the Consumer Product Safety Commission should be ensuring that dangerous products aren't able to make their way to store shelves and harm children. The FDA, the Food and Drug Administration, should be focused on preventing the spread of foodborne illnesses. These are regulations that help keep people alive. The EPA, Environmental Protection Agency, should be keeping our air and our water clean. As a guy who lives in Newark, New Jersey. I have seen the consequences when regulations aren't enforced and people get horrific diseases. A New Jersey-based pediatric oncologist recently reached out to my office and shared, quote, that as physicians, we take an oath to do no harm, but every day health professionals see patients whose health is harmed not by choices they make, but by the air they breathe, the heat they endure, and the environmental conditions that are out of their control. And often, these environmental conditions out of their control are in areas and communities like mine. Low-income communities. I live in the Central Ward of Newark, New Jersey, where I see people who do everything right. But the toxins in the air, toxins in their soil, toxins in the water endanger their lives. Our agencies must be focused on promulgating regulations that keep Americans safe and healthy. What I worry about is when people bring in a political philosophy that ultimately helps to weed out perhaps some good regulations, but often makes it easier for very powerful economic interests to inflict more harm on Americans. President Trump rolled back over 100 environmental regulations during his first administration. And I watched the pollutants of particulate matter in the air that my community, my state breathes, get worse, making conditions from emphysema to asthma get worse, costing people their health. In the second administration, he's already targeting environmental regulations that exist to keep our air and our water clean and from kids getting sick with cancer due to man-made pollutants. The idea that deregulation is the solution to our current lack of competitive markets is wrong if that is an eye towards eliminating the regulations to keep people safe. It is decades of de facto deregulation during which enforcers neglected to block anti-competitive mergers and challenge monopolies that has got ourselves to a situation today where we have such concentrated markets that work against the best interest. This picking and choosing of which regulations work for the most powerfully connected, armed with lobbyist organizations and not ones that are based upon keeping people healthy. To suggest that doubling down and further deregulating our excessively concentrated markets will only help help undermine competition. This idea that deregulation will increase competition is in and of itself a flawed idea. It is the role of our antitrust enforcers, the Federal Trade Commission and the Antitrust Division of the Department of Justice, to promote a competitive economy, a free market, and ensure our antitrust laws are being fully enforced. If we want to support competition, we must empower our federal antitrust enforcers. Congress must increase their funding and provide them access to merger filing fees so they have the resources to challenge anti-competitive mergers that enable consolidation and full staffing to conduct investigations to uncover anti-competitive activities. If we want to fight anti-competitive behavior, we cannot weaken the leadership of these agencies. A president who unlawfully removes 2 Democratic commissioners, Rebecca Kelly Slaughter and Alvaro Bedoya, is not focused on fighting concentration. In fact, that kind of rank partisanship is undermining our ability to have a more fair market. It is actually enabling powerful business donors to make sure they don't face rollbacks when their companies are attempting to finalize anti-competitive mergers. This is corruption. This is corruption. When those folks who are before these agencies seeking mergers can give millions and millions of dollars to politicians to get their way. This is corruption. And if we want to repeal anti-competitive regulations, we do so in accordance with the administration's Procedure Act's required notice and comment process. We do not embed a group, and forgive me to all the undergraduates here, but we do not embed a group of undergraduates into our federal agencies and have them to rely on a black box AI algorithms to determine which regulations to keep and which ones to eliminate. I'd like to enter into the record this article entitled "Doge Put a College Student in Charge of Using AI to Rewrite Regulations."
Without objection.
Thank you, sir. During today's hearing, I look forward to examining the many ways in which the federal government can ensure that every American, every business, no matter what their size, has the ability to fairly compete. Our democracy, our economy benefits from fair competition. How we prevent regulatory capture by some of America's wealthiest companies who are putting more and more money into political contributions, more and more money into lobbying. How do we have a system that's fair when they could put unlimited funds to lobby these rulemaking agencies and to give to the politicians who are exercising control over them? How do we empower our federal agencies to enforce our antitrust laws? Every American, every business, every worker deserves to have that economic liberty. And I look forward to hearing our witnesses on how we can do that, and perhaps how we can have a market that is free at last, thank God Almighty. Could be free at last. Thank you very much. Coming from you, that's extraordinary. Mr. Chairman, I yield my microphone to you, sir, for the introductions.
Thanks so much. Beautiful, as always. Well done. All right, let's introduce our witnesses now, and then I'll swear them in. We've got five really good witnesses for today's hearing. First, we're going to hear from Commissioner Mark Meador, Commissioner on the Federal Trade Commission, then from Doha Mekki, Senior Fellow at the UC Berkeley Law School's Center for Consumer Law and Economic Justice, rather. Then from Roger Alford, who's the Principal Deputy Assistant Attorney General. It's very important to get the order of those words right, because all titles at DOJ include some combination of those words. And he holds that position within the Antitrust Division at the U.S. Department of Justice. Next, we'll hear from Bill Bullard, CEO of RCAF, and finally from Professor Daniel Francis, a witness from whom we've heard many times, along with others on this distinguished panel. He's a professor of law at New York University Law School.
And he has a spectacular tie. I don't know if you've gotten a look.
It is spectacular. I can't see it in detail from here, but it is lovely. I always have to be careful with a group of lawyer witnesses that expressio unius non exclusio ulterius here. All right, if the witnesses will please stand and raise your right hand. Do you swear or affirm that the testimony you're about to provide before the subcommittee will be the whole truth, the whole truth, and nothing but the truth? Thank you. Let the record reflect that each of the witnesses answered in the affirmative. Thanks again for being here today. We'll begin with Commissioner Meador and then move forward to my right, your left, from there, with each of you having the allotted time. There has, just for your information, there's been a vote called on the Senate floor. It's awful that we can't ever seem to coordinate all of these with committee and subcommittee hearings. That means each of us will have to, at one point or another, step out, go to the floor, and come back. So in a few moments, I'll be leaving. I'll hand the gavel to Senator Booker, and he'll hold the gavel until such time as I get back.
That power will go to my head, and I shall abuse it, but thank you.
Thank you. Commissioner Meador.
Thank you, Chairman Lee, Ranking Member Booker, and distinguished members of the subcommittee. My name is Mark Meador, and I serve as a commissioner on the United States Federal Trade Commission. Before starting, I should note that I'm testifying in my personal capacity. My comments are my own and do not necessarily reflect the views of any other commissioner or the commission. It is a great honor to join you today. I spent several years serving as a staffer on this subcommittee in the office of Chairman Lee, and I truly appreciate the important work you and your talented staff carry out. I'll add that in preparation for this hearing, I had a lively back and forth with subcommittee staff about whether it was better to be in my seat or their seat, but I won't out which side anyone took. On April 9th of this year, President Trump issued the executive order reducing anti-competitive regulatory barriers. That executive order drew attention to a stark reality. All too often, federal regulations passed in the name of the American people don't actually serve the interests of the American people. I'm proud to affirm with President Trump that regulations that reduce competition, entrepreneurship, and innovation, as well as the benefits they create for American consumers, should be eliminated. The FTC is taking active steps to implement this executive order. On April 14th, in accordance with the order and in partnership with the Department of Justice, the FTC launched a public inquiry into the impact of federal regulations on competition. In response, the FTC received numerous thoughtful submissions from individuals, businesses, and organizations across the country. There was a consistent theme. Americans want a fair chance to compete. Here are some of the key trends we have seen so far. In the healthcare sector, the FTC heard that scope of practice laws limit the ability of nurse practitioners, CRNAs, and other non-physician providers to deliver care that they are fully qualified to provide, especially in rural and underserved communities. Price opacity and non-compete clauses limit choice, accountability, and mobility for both patients and providers. Licensure and certification requirements erect barriers to entry and advantage incumbent hospital systems and large providers. And Americans' concerns ranged well beyond just healthcare. In the transportation sector, commenters cited regulatory barriers ranging from gate access restrictions in aviation to inconsistent licensing and ride sharing to uneven standards for electric vehicle infrastructure, all favoring incumbent players. In the digital market sector, commenters flagged restrictions on access to public data sets and uncertainty around content liability laws as challenges. In the education and childcare sector, community providers noted that childcare and early education regulations disproportionately burden small and home-based operators. This undermines affordability and access to private education. I could go on and on. In each of these cases, the pattern was clear. Incumbents are using existing regulations to avoid competition. That's why in the days to come, the FTC will continue to carry out its review of anti-competitive regulations in order to better promote competition in American markets, in partnership with the Department of Justice, the White House, and other stakeholders, including, importantly, the states. Before I close, I want to stress an important point. The problem highlighted by the President's executive order is not merely a matter of individual regulations. It is the act of regulation itself as a policy approach. You have all seen representatives from a number of dominant firms in emerging sectors, especially the tech industry, come before you, and they often have a familiar line. Regulate us, some of them ask. And this can seem very public-spirited, but when powerful companies ask for regulation, what they are often really asking for is entrenchment of their own monopoly power. They can afford to pay compliance costs. Their startup competitors cannot. Bad faith requests for regulation only serve the interests of powerful firms. What they seek instead of real accountability is a narrow, predictable regulatory regime, one that they alone can navigate, budget for, and ultimately capture. This form of regulation does not deter illegal behavior, it normalizes it. Top-down regulation changes the calculus of misconduct, making it into something to be priced, managed, and repeated. What's the alternative? Well, it's twofold. Targeted consumer protection enforcement when companies harm consumers directly, and targeted antitrust enforcement in the event companies behave anti-competitively. This dual mandate is precisely why the Federal Trade Commission exists. The FTC has far more powerful misconduct deterrents at its disposal than what static and slow-moving regulatory schemes permit, and it will wield them in accordance with the law. Through this work, the FTC is committed to preserving a competitive and healthy marketplace that promotes and protects the well-being of American consumers. Thank you, and I look forward to your questions.
Thank you very much. Our next witness.
Chairman Lee, Ranking Member Booker, and distinguished members of the subcommittee, thank you for holding this hearing. Against the backdrop of this hearing, Americans are confronting a painful cost of living crisis. Nearly half of renters spend more than 1/3 of their income on housing. Home ownership increasingly is a luxury of the older and wealthier Americans. Egg prices are nearly 60% higher than they were just a year ago. Car payment default and repossessions have reached levels unseen since the financial crisis. Let me be crystal clear. Our fellow Americans cannot easily afford their economic independence. And if you care deeply and passionately about the American people, as I do, this is untenable, especially in a country as extraordinary as ours. In antitrust, as in life, I acknowledge there is much on which people of goodwill may disagree. But in my experience as an enforcer and practitioner, it is appropriate for the government to be concerned with both public and private regulation. Let me explain. The government can and should eliminate anti-competitive regs. The ability to lobby for cushy, lucrative regulations that squeeze out competition is often downstream of unchecked monopoly power and oligopolistic markets. At the same time, the government plays a vital role in checking private regulation, those systems of anti-competitive restraints and unfair dealing imposed on all of us by monopolies and cartels that prefer to be free from ordinary market forces. Often enough, rule by monopoly is a type of unaccountable private government and system of taxation unto itself. I've sometimes heard people say that government can best promote competition by being hands-off. Respectfully, this fundamentally misunderstands the realities and incentives of private coercive power. When our government, which is democratically and constitutionally accountable, decides not to fashion rules of the road, this too is a choice about how to shape the evolution and structural integrity of markets. Why? Because where law does not set out the rules of the road, entrenched monopolies and cartels may act to fill the void, sometimes in ways that are unfair, rife with conflicts of interest, and that put the interests of a small number of behemoths over those of citizens. We see this in healthcare, tech, and agriculture. Dominant corporations impose a private system of rules and taxes on consumers and market participants. Beyond their first-order competition harms, these abuses erode economic independence, and with it, the public's faith in our market economy and our democratic institutions themselves. Congress has long understood the wisdom of competition as the rule of trade. Our best conception and our highest ideal of a competitive market is one where companies win on the merits and the best ideas win out, where labor markets are free and companies can compete for talent, where new entrants and nimble upstarts nip at the heels of dominant incumbents, and where new paradigms are ushered in by technological breakthroughs that benefit from investment. The Supreme Court has long understood this too. So the inquiry before us isn't the relative merits of regulating competition, but to define the proper role of the government to safeguard competition. It is the government's first duty, after all, to keep the American people safe, and that means safeguarding liberty in all of its forms, including economic liberty. The antitrust agencies should be focused on the most challenging competition problems facing the most people. Agency leaders may face some superficial temptation to divert their resources to deregulatory projects that sound in competition. This work can make agencies look and feel busy, but diverting enforcement dollars comes at a serious opportunity cost. It distracts from the essential core of their missions, antitrust enforcement against illegal mergers, monopolies, conspiracies, and cartels. The agencies are uniquely suited to surface and take on the biggest, most intractable competition problems. And that is especially true of the Antitrust Division, where I spent 10 years of my life, which has a long and storied tradition of trust busters who took the idea of economic liberty and turned it into material progress for the American people. I urge the agencies to stay true to their missions. Insufficient enforcement is at least as responsible for markets hobbled by abusive monopolies and conspiracies as anti-competitive regulation. With cases against Google, Agristats, Apple, Visa, Ticketmaster, RealPage, United Health, and more, the DOJ's antitrust enforcers have made bold strides to pry open the forces of competition and markets we rely on. It is an impossibly sad fact in this country that ordinary Americans cannot easily vindicate their economic liberty. We need government to help preserve the contestability and resilience of markets. Therefore, I hope the administration will continue to protect the gains that enforcers have made in recent years, while at the same time devoting more resources to the crises of the moment. Let me conclude now in the interest of time. I look forward to engaging your questions.
Thank you. That was incredible testimony. I don't mean to quibble, but you referred to me as the ranking member. I am the acting chairman, okay? I am Thor with the hammer. The next witness, please.
Let me enter my apology into the record.
For the record, please. I hope you got that recorded, my friend. You got that, okay.
Chairman Lee, Acting Chairman Booker.
Thank you.
Members of the subcommittee, thank you for inviting me to testify today on the important topic of antitrust and deregulation. I have testified here before on a number of occasions as a law professor at Notre Dame, but this is the first time I have had the opportunity to testify before you on behalf of the United States Department of Justice. So last time I had my Notre Dame colors, this time I have red, white, and blue. It's a great opportunity to talk about antitrust and America First Antitrust, and I welcome the invitation. It's an honor to work with Assistant Attorney General Gail Slater and the wonderful attorneys, economists, and staff at the Antitrust Division. Under her leadership, we are committed to vigorous antitrust enforcement based on conservative principles, individual liberty, free markets, respect for precedent, and strong support for deregulation. The topic of this hearing focuses on the last point, the relationship between antitrust and deregulation. Now, it goes without saying that all regulations are not created equally, and the focus that we have today are on anti-competitive regulations. Anti-competitive regulations restrain the competitive process that we rely on to maximize consumer welfare. They sap our economy of dynamism and threaten our future global competitiveness. The Antitrust Division opposes both private conduct and public regulations that threaten American competition. We are not regulators at the Antitrust Division, we are law enforcers. By enforcing the Sherman Act, we stop cartels and monopolies from exploiting their power to act as governors of their industries by imposing rules and policies that stifle competition. Powerful firms engage in private control of the market because they have an incentive through cartels or monopoly abuse to exclude competition to protect their profits. But they also have an incentive to lobby the government and capture regulatory processes to raise barriers to entry and build moats around their castles. Public regulation can be a powerful exclusionary tool, and we should be concerned about the distorting impact of both government and corporate abuse of power. America First Antitrust enforcers embrace free markets and competition on the merits. It is skeptical of government intervention in the markets as well as corporate power, especially the kind that colludes with the government to harm consumers through anti-competitive regulations. As you all know, there is a massive ecosystem of consultants and lobbyists who push regulatory agencies toward imposing durable regulations that stifle the free market. It is an astonishing fact, but true, that lobbying of the federal government is at an all-time high, exceeding $4.5 billion in 2024. Precisely what are corporations and their surrogates receiving as a return on that investment? Members of this committee and their staff are on the front lines of responding to the crushing burden of corporate lobbyists seeking public favor to distort the market. AAG Slater has directed the Antitrust Division to work to counterbalance private interests and serve as a competition advocate. As she explained in a recent address at Notre Dame Law School, corporate lobbyists using their power to undermine free markets is ubiquitous in our system, and small but powerful groups can dominate regulatory processes at the expense of the diffuse interests of individual citizens. The alliance of big business and big government must be broken. Fortunately, President Trump has issued an executive order on deregulation to break the alliance between big business and big government. Implementing the mandate of the EO is well underway at the Department of Justice. Both the DOJ and the FTC have called for public comments on anti-competitive regulations, and we have started engaging with regulatory agencies, preparing a consolidated list of recommendations for OMB. The DOJ's Anti-Competitive Regulation Task Force is leading the charge within the Department of Justice to carry out the President's executive order. The division is leveraging its substantial experience with regulated industries to inform the deregulatory analysis of other federal agencies. We have received more than 400 responses to our call for public comments that reveals an economy weighed down by burdensome regulations. Almost half of these relate to the healthcare industry, 20% relate to agriculture, approximately 5% to housing, 5% to transportation, et cetera. The comments span the U.S. economy and reflect many pocketbook issues. We heard from nurses, farmers, home health aides, truckers, grocery store owners, men and women from all walks of life who spoke about the burdens of anti-competitive state and federal laws and regulations, and I outline these in my written testimony. Our economy is premised on the idea that the best way for regulating markets is, whenever possible, lifting the consumers to express their preferences through the give and take of competition. And that is our goal at the Department of Justice. Thank you very much.
Thank you very much for your testimony. Excellent testimony. And I appreciate you giving me the right address. I'll forgive you then for not mentioning my 5 catches against Notre Dame when Stanford played them in 1990, but that should be in the record as well. Thank you very much. Mr. Bullard.
Thank you, Mr. Chairman, and acting chairman.
Thank you very much.
Booker, and members of the committee. I'm Bill Bullard, CEO of RCAF USA, which is the largest producer-only trade association representing the U.S. cattle industry. We represent only the farmers and ranchers who raise and sell live cattle. Along with our thousands of cattle-producing members, we also represent America's sheep producers, and thus we represent the backbone of U.S. agriculture, as the U.S. cattle industry alone is the largest segment of American agriculture. Our U.S. cattle and sheep ranchers are the last bastion of independently owned family-scale livestock grazers and feeders in America. But for decades, our ranchers have been dropping like flies, hollowing out rural communities across America, and our ranching industry is being decimated by a combination of unrestrained globalism and market concentration. In just over a generation, over half our nation's cattle farmers and ranchers and nearly 2/3 of our commercial sheep ranchers have ceased operations. Our breeding cattle and sheep inventories declined by 9.2 and 7.6 million head respectively, relegating our cattle herd to the smallest size in 7 decades, and our sheep herd to the smallest size in history. And our family-scale feedlot operations declined by over 75%. Last year, over 73% of all the lamb consumed in America and 22% of the beef consumed in America was imported, indicating that the U.S. is fast becoming dependent on foreign supply chains for its important beef and lamb. All of this even though our U.S. population had increased 49% during the same period, and both domestic beef and lamb consumption has increased significantly over the past decade. The cattle and sheep industries are in crisis because the packing industry was granted a decades-long de facto deregulation for both antitrust laws and the Packers and Stockyards Act. As a result, ranchers have remained unprotected from both monopolistic marketplace harm and harm from unfair and anti-competitive buying practices of the highly concentrated meatpacking sector that wields tremendous buying and selling power to the detriment of both ranchers and consumers. This de facto regulation caused such explosive growth in beef packing concentration that the U.S. Department of Agriculture stated in 2000 that no other manufacturing industry shows as dramatic an increase since the U.S. Census Bureau began regularly publishing concentration data in 1947. In 1980, the four largest packers controlled 36% of the fed cattle market. Today, they control approximately 80%, and they have done so for nearly 2 decades. This is the market that monetizes the entire U.S. live cattle industry, from the cow-calf sector to the feedlot sector. And this de facto deregulation of the marketplace has created a dangerous bottleneck, and think of the shape of an hourglass, in the center of the beef supply chain, where the cattle industry ends and the beef industry begins. And given their gatekeeper status and inherent market power, they are powerful oligopolists capable of exerting abusive market power upstream into the cattle supply chain to reduce cattle prices paid to producers, and downstream in the beef supply chain to increase consumer beef prices. The beef packers have all but eliminated competitive market forces within our industry, and they've replaced them with corporate control. A chart in my written testimony illustrates the effects of market power pervading the beef supply chain, showing a broken market that caused consumers to pay ever-increasing beef prices while cattle prices were falling, a phenomenon that cannot be explained by competitive market fundamentals, particularly when one considers the only ingredient in beef is cattle. And no one looking at this chart can say our cattle and beef markets are functioning fine. Ranchers at one end of the supply chain and consumers at the other are being exploited. An example of how the beef packers leverage down their cattle prices is that ranchers can sell cattle from 4 different baskets, each with their own incremental variations. However, only one of those 4 baskets control the base price for all cattle. That basket is the cash market. And the packers have shifted large volumes of cattle out of that basket into another, leaving the cash market ultra thin and highly susceptible to manipulation. And what this means is the beef packers can now lower the price of all of their cattle from all 4 baskets by manipulating simply the ultra thin cash market, which now stands at about 18%. Our cattle and sheep markets are fundamentally broken, and we ask Congress for its intervention to begin rigorous enforcement of our U.S. antitrust laws and to follow through with the Packers and Stockyards rulemaking that began with the previous administration. We need the enactment of the American Beef Labeling Act to restore mandatory country of origin labeling in the beef market to provide transparency for both producers and consumers. And Chairman and Acting Chairman, we fully support your OFF Act that reforms the broken beef checkoff program. With that, I'm happy to answer questions. Thank you.
Chairman Lee, Ranking Member Booker, Members of the subcommittee, thanks for inviting me today, and thanks for being so nice about my tie. I strongly support the subcommittee's investigation of regulations that harm consumers and workers by restricting the supply of goods and services. Special interests love these laws at both the federal and the state level, but consumers and working families always pay for them. I want to highlight 5 clear bipartisan cases for congressional action. Number 1, certificate of need laws. So in about 35 states, hospitals and other healthcare providers often can't enter markets or expand unless a bureaucrat first certifies that there's a market need. Now, just as you'd expect, incumbents use and abuse those systems all the time to block entry, entrench monopoly, and harm patients. Now, unfortunately, these laws were pushed on the states by federal legislation in the form of a congressional mandate in 1974. Congress repealed that mandate in '86, but the laws are still on the state books. I think it's time to fix the problem by incentivizing repeal and reopening our markets. Number 2, certificate of public advantage laws. Decades ago, the Supreme Court gave state governments the power to grant antitrust immunity to private businesses, even for the most harmful mergers. And states have gone out and used that judge-made power to enact public advantage laws, blessing private mergers that create hospital monopolies, while the federal antitrust system sits powerless. Now, that loophole obviously invites abuse, and that is exactly what it gets. Patients suffer as a result. All being done in the name of congressional intent. I don't think that Congress intended anything of the kind when it constructed the antitrust system, but today only Congress can bring it to an end. Number 3, the Robinson-Patman Act. The RPA was written by lobbyists for business and passed in 1936. It makes it legally risky for a business to discount to one of its customers without also sharing that discount with its customers' rivals. Now, discounting is great for consumers. It lowers the prices that they pay. But the RPA discourages that in 2 important ways. 1, it discourages sellers from giving that discount because they know they're going to have to give it to many more customers. And number 2, it discourages buyers from asking for a discount because they know if they get it, it's going to be shared with their rivals. Now, for decades, enforcers from both parties refused to harm consumers by enforcing this law. But today, it's on its way back. Don't let our scarce antitrust enforcement resources take from consumers and give to businesses. It's time to repeal the RPA. Number 4, the Jones Act. So here's how I think about this one. If a foreign power were making the United States rely on a handful of old and overpriced ships for all our domestic trade, while letting our foreign competitors use cheap, efficient, modern ships to compete against us for sales into our own domestic markets, we would call that economic warfare and a national emergency. But we've been doing that to ourselves for a century. The Jones Act manages somehow to force us to live under conditions of scarcity and sky-high pricing in the middle of a global oversupply of shipyard capacity. And it hasn't even given us a viable domestic industry in exchange. We make hardly any large commercial ships, and the only people who buy the ones we do make are the people who are forced by law to use them. This is just protectionism for foreign competitors paid for by American businesses and American consumers. I strongly support Chairman Lee's bill to repeal the Jones Act. Number 5, and finally, licensing recognition. Across our country, workers are denied the right to move and work across state lines. States routinely disadvantage out-of-state licenses, even when the license holder has equal or superior qualifications to in-staters, but the reason they do it is that incumbents are pulling the strings. Workers and their families get locked out of interstate markets, businesses can't hire the best people, and consumers pay more. Congress should act, either by incentivizing recognition or creating a federal system. There's plenty more in my written testimony, but I'll leave it there for now. Thank you for having me today, and I look forward to your questions.
Thank you so much. I appreciate all of your testimony, and sorry that I missed some of the opening statements. Let's go right into it now. We'll go back and forth between Republicans and Democrats in order of seniority and arrival, and we'll begin with that now with 5-minute rounds. Commissioner Meador, I'd like to go to you first. How do you think principled and consistent antitrust enforcement can diminish or in some cases even obviate the need for prescriptive regulation?
Thank you. It's an excellent question. The two are closely connected. I was thrilled to hear other witnesses highlight this, as well as your remarks and Ranking Member Booker's. When we have robust, strong antitrust enforcement, that's what helps maintain competitive free markets. Regulation is at the opposite end of the spectrum. That typically comes in when there's been a market failure. And one of the purposes of strong antitrust enforcement is to prevent those market failures. And so I think it's critically important that we maintain strong enforcement. You know, we hear about companies today that like to brag, saying that they can move fast and break things, but the FTC will move fast and break things up. And if their conduct harms competition, we will step in, because antitrust enforcement today prevents the need for regulation tomorrow.
Right. And that's often true, especially if what's being broken up is being broken up because it's anti-competitive rather than because it's big simply as such or for some other reason. Mr. Alford, your testimony describes an alliance between big government and big business, one that uses the rulemaking process rather deliberately in order to place barriers to entry into that marketplace. In other words, it's one thing if regulations have the incidental effect of creating a moat, an anti-competitive moat around market incumbents. It's quite another thing when that is the design, when it's the feature rather than a bug. What can be done to prevent this sort of thing going forward?
Yeah, thank you for your question. Again, as you suggest, different regulations have different purposes, and I think the kinds of regulations that we should be the most concerned about are the ones where there is agency capture or where there is corporate lobbyists that are simply trying to increase the barriers to entry for other competitors. Often, the scenario in which that happens are large companies, big ag, big tech, big pharma, can raise barriers to entry and accessibility to the market for the lower, small and medium-sized companies. And there's a whole variety of different ways to prevent the problem. It depends if you're asking about going forward to prevent future such regulations or going backward to try to undo some of the previous ones. Our focus has been on trying to undo some of the anti-competitive regulations that have been enacted that fall into that category, where there has been agency capture or laws that are passed because of corporate lobbying. In terms of going forward, obviously, much of the problem should be greater transparency and recognition about the influence of these sorts of lobbying efforts, about what the purpose of the laws are. Very often, if you read between the lines to try to really drill down, they have to make up a reason why this is in the public interest, but it very often is not really a credible argument. I've seen that in numerous occasions. So much of the effort, I think, would be on trying to have regulations, agencies and Congress be sensitive about what's the true purpose of what they're trying to accomplish.
Right. I suppose one approach that one could take, at least prospectively, would be a reform like the REINS Act, which would require Congress, with regard to major rules, to be the ultimate decision-making authority on whether to propose it as new legislation. Article 1, Section 7 certainly tends to contemplate that you can't make or amend federal law without following that process. That would at least allow these considerations to be undertaken. Professor Francis, your testimony highlights some of the problems with licensing, occupational licensing recognition, the barriers that some of those things provide, particularly to military families who, by virtue of their military service, frequently have to move from one place to another. Most of these occupational licensing regimes, of course, are creatures of state law, not federal. So what steps do you think can appropriately be taken at the federal level in order to diminish this problem, either by encouraging states to reduce unnecessary licensing burdens without compromising quality or safety, or otherwise?
I think, Mr. Chairman, that's exactly the key question. Everyone recognizes the policy problem. What are we going to do about it? And while it's true that these systems are created by state law, the problem, at least the one we're talking about today, is distinctively a congressional concern. It's the impact on interstate commerce, and specifically the borders that workers and their families, both in and outside of our military, face when they try to exercise that sacred constitutional freedom to enjoy open and competitive interstate labor markets. So with that in mind, I think there's a spectrum. At the mildest end, you could imagine federal incentives that encourage but don't require states to adopt interstate recognition programs, either in specific areas, specific professions, or more generally. Cranking up the intervention a little bit, you could imagine a federally operated but voluntary for states recognition system, perhaps operated by the Department of Labor or the FTC, where individual states can notify the Department of Labor of their intention to participate in the federal program. And by doing so, they get mutual licensing recognition with any other state that chooses to participate. So again, that's the federal government as a facilitator, not as a director. One more notch along the spectrum, you could imagine federal licensing of some professions. Might not want to do that in every case, but across the board, you can see occupations where it wouldn't be crazy to imagine the Department of Labor or perhaps some other branch of the government establishing perfectly reasonable requirements and giving workers the freedom to apply for an interstate federal license, maybe even a federal bar exam, recognizing there are plenty of attorneys in the United States who only practice in federal courts. Finally, at the far end of the spectrum, you could imagine Congress really leaning in to protecting interstate commerce and labor and creating a mandate, creating a federal right to work across state lines that to the extent you've obtained a license in an individual state, that provides you with a federal freedom to work in any state that has equal or lower barriers to entry. That would be a remarkable intervention that would concretely do a lot of good for a lot of people.
Yeah, those are great points. You've got me thinking. When you refer to the Commerce Clause interest at stake, there are existing judicial remedies, at least in theory, available for circumstances where a state discriminates either facially or in effect on a product, here a service, based on its origin or destination out of state or outside the United States. Typically, you're going to face a pretty tough battle if it facially discriminates, but you might also face another battle, and there might be a judicial remedy, even in the absence of facial discrimination, if you can show that the putative non-discriminatory benefits are substantially outweighed by a detrimental effect on the ability to deliver that service from across state lines. Now, that judicial remedy tends to be pretty hard to come by. But I think what you're suggesting is that federal legislation building on those could change some of that difficulty in a way that is compatible with federalism.
I couldn't agree more. So I take your first observation to be, wait a minute, don't we have a Supreme Court created, long settled, dormant Commerce Clause doctrine that is supposed to guarantee to every citizen in the United States and every person who's working in the economy the freedom to be free from state level or local protectionism and discrimination? You are exactly right, and I think the failure to recognize licenses at the state border raises serious problems under the Dormant Commerce Clause. That's actually the next academic project that I'm planning to pick up.
Excellent.
But access to litigation isn't a practical option for everybody. These licensing regimes don't just apply to, high-paid doctors and lawyers. We're also talking about an astonishing array of professions. We're talking about plumbers. We're talking about personal trainers. We're talking about landscape gardeners. I'm not sure it's practical to hope in a meaningful way that those folks are all going to be able to litigate their way through to interstate commerce, recognizing also that there has been a pretty striking tradition of judicial skepticism of this Dormant Commerce Clause doctrine in a way that I actually think runs right in the face of the original meaning and expectation of the way the Commerce Clause was going to operate on behalf of American workers. So while I think the Dormant Commerce Clause should be doing exactly this work, that is not the experience on the ground. It's been clear for decades, and that's why I think affirmative congressional leadership would be so valuable here.
Right, well, particularly for poor middle-class Americans. I mean, it's one thing if you represent a large industry group and can afford to litigate these difficult to litigate, under these difficult to litigate standards. But we should look into that. Anyway, thank you for looking into this, and thanks for plugging the Dormant Commerce Clause. In my hometown of Provo, Utah, we speak of little else. Senator Booker.
Mr. Chairman, may I suggest, being that you and I are here for the duration and love nothing more than discussing the Dormant Commerce Clause, that we allow Senator Blumenthal to go first. There's a lot of demands on our colleagues' times today with lots of competing, and then maybe go over to Senator Hawley and then back to me.
Sounds great.
Okay.
Thank you, Senator Booker and Senator Lee, for having this hearing, which I think is eliciting a lot of bipartisan interest and support for action. I want to call attention to one area where Senator Hawley and I have been working, which is forced arbitration. We all know the importance of enforcement of antitrust laws and, in fact, of our laws in general. A prohibition or any law is dead letter if it's unenforced. And as a former Attorney General, I enforced antitrust laws. I believe that there ought to be public enforcement of them, but private attorneys general also can play a role. And that's why I think that the present barriers raised against private enforcement, such as forced arbitration, should be taken down. And I have been the lead sponsor on our side for the Forced Arbitration Injustice Repeal Act, which would end the use of these clauses for a variety of claims in employment, consumer rights, and civil rights, and also antitrust disputes. We have eliminated forced arbitration for sexual harassment and age discrimination claims. I've been proud to help to lead those efforts. I think it's time we move a bill to bar these kinds of clauses for antitrust claims as well. And I hope that all of my colleagues on my side and the other side of the aisle will join me in that effort. Let me begin, Ms. Mekki, and then others, if you're interested, to get your opinion on that point.
Thank you, Senator. I think the value of an ordinary person being able to go into court and vindicate their economic liberty in an antitrust case is extraordinarily important. And thinking about the myriad barriers to doing that, right? Staring down a huge company that has violated an economic right, getting over potential retaliation, the army of lawyers, deeply resourced companies can often hire very elite law firms, right? If you get through all of that thicket of issues that prevent you from vindicating your own economic liberty only to be forced into a private, publicly unaccountable forum, that is not justice. And so there may be instances where some big corporations may elect to resolve their disputes privately against each other. That's not what we're talking about here. We're talking about the more than 300 million Americans who need to be able to air out their concerns, and where we can see, as former enforcers, as practitioners, the development of law that is so important to really structuring our entire market economy.
Yeah, I can also speak to that briefly. In addition to antitrust, I also teach international arbitration at Notre Dame prior to my stint here at the DOJ. And the dilemma is this: you have adhesion contracts, typically in electronic commercial agreements, and the fine print of those agreements specify that there shall be no litigation, that you'll be forced into arbitration, and that you cannot have any class action. So there's no class action litigation, and there can be no litigation at all, and you can have no class action arbitration as well. And then, of course, in the context of adhesion contracts, the question is whether or not there is sufficient genuine consent to those sorts of arrangements. So that's the dilemma that is faced by those sorts of things, and these sorts of bills have been proposed for years. At the DOJ, obviously we can't take an official position on legislation without it being properly vetted within the various offices of the DOJ, but that's the dilemma that the bill is trying to address, I think.
Well, when you say it's the dilemma, I'm assuming the use of that word is designed to be somewhat sympathetic to the cause of enforcement in the private sector, and you've just mentioned fine print. Often it is very, very, very fine print, unnoticed by the person who ultimately may want to bring a lawsuit, and also it is the result of an imbalance of power where the one side has much more power than the other in becoming subject to that kind of clause.
That's correct.
Let me ask, in the very brief time that I have, if I may, Mr. Chairman, another quick question to Mr. Meador. I wonder if you could tell me the Open App Markets Act, which Senator Blackburn and I are introducing today, reintroducing, which would grant the FTC and the DOJ greater enforcement authority, as well as provide a private right of action to app developers with injunctive relief and significant treble damages as a deterrent. I know that my staff worked closely with you when you worked for Senator Lee. I'm sure you missed that job fervently. But I'd like to ask you briefly for your views on the bill.
Thank you, Senator, for that question. So I can't take an official position on the bill, but I can say that it's incredibly important for this body to engage with these issues. The antitrust laws are very flexible and adaptable to new markets and new technologies, but there is always a lag as we have to investigate and bring cases. And oftentimes, it's Congress that has the opportunity to step in sooner, recognize a problem in the marketplace, and offer a solution. And of course, your solutions come with a stamp of Democratic approval. And so we always welcome further guidance from Congress on how to navigate these important policy choices in the marketplace, and of course, additional tools to stop conduct that's harming consumers.
This bill is bipartisan. I hope it will pass, and I hope it will gain the support of your agency as well as yourself. Thank you, Mr. Chairman. Thank you.
Thank you, Mr. Chairman. Thanks to the witnesses for being here. Mr. Meador, I want to pick up where Senator Blumenthal started as well, this question about private enforcement and forced arbitration. You've said, I think, that antitrust is law enforcement, full stop. Wouldn't you agree that private enforcement is essential to a functional antitrust regime?
Absolutely. American antitrust enforcement rests on three pillars of a stool. One is the federal government, the second are state attorneys general, and the third are private plaintiffs. I think I agree with Ms. Mekki's comments 100% that it's essential for the average person to have the ability to come into court and vindicate their individual economic rights.
But they really don't today, do they? I mean, in case after case, particularly if you're dealing with companies of any size, and let's take our friends in the big tech world, for example. I mean, all of their user agreements are full of the classic contracts of adhesion. I mean, Google, you waive your right to sue us in court or to bring a class action case. I mean, there's virtually, I don't want to say no ability, but very, very diminished ability for any private citizen to bring any meaningful antitrust suit privately. I mean, isn't that real? Isn't that right?
I agree that's a real problem, and it highlights the need for strong enforcement that can make it easier for private plaintiffs to bring follow-on lawsuits. But even then, as you point out, if you're subject to a forced arbitration clause, that can be more difficult.
And wouldn't it be much more powerful in the antitrust sphere if we could also bring class action suits? Private plaintiffs could bring class action suits, which again are theoretically possible, but effectively barred by many of these adhesion contracts, right?
I agree. In many instances, a class action suit is actually the most efficient way to resolve these big questions.
I mean, so to me, this speaks for the need, given what these companies are doing, given what some of the courts have done doctrinally, it speaks to the need for Congress to legislate on this topic and to give, frankly, antitrust enforcers more tools and allow private litigants to get into court, allow private litigants to bring class action suits to enforce our nation's antitrust laws. I mean, don't you think that if Congress were to put a stop to these forced arbitration clauses in the antitrust context, we'd see a lot more private enforcement? I mean, would that be your prediction, Mr. Meador?
That is what I would expect to see.
Do you want to weigh in on this, Ms. Mekki, at all?
I think this is extraordinarily important. Having access to lawyers to help vindicate your liberty in the form of damages is very, very important. But I would say that in the ecosystem that my friend Commissioner Meador just sort of outlined, class action cases are very good at getting people monetary damages, but it is really the federal government that takes the mantle for getting injunctive relief and equitable relief. And so when I was at DOJ, I had the privilege and great fortune of helping to sue Google twice and winning twice. And so when the Justice Department is in court fashioning remedies, they're talking about opening up markets, not just getting people money, which is important too, but making sure that our markets are delivering for the American people and are open for investment and innovation.
Yeah, so it's a both and, right? I think it's what you're saying. Yeah, but those damage awards, let me put it to you this way. When the FTC in 2019 fined, I think it was Facebook, $5 billion, if I remember correctly. Yeah, fined Facebook $5 billion. I remember I was brand new senator. I was new up here, and I thought, $5 billion, that's a lot of money. I thought Facebook is really going to change its behavior now. Not so much. Their stock prices went up the next day. They did nothing meaningfully different. I agree with you completely about the need for robust federal enforcement, and I am a former state AG, Senator Blumenthal is as well, so I know that we believe in robust enforcement at the state level also. But there's something powerful about a damage award from a jury. I mean, to have private enforcers be able to get into court, get in front of a jury, particularly in a class action context, it's one of the reasons that these companies have fought Section 230 in a different context for years and years. They don't want to face juries. And I think the same is true for antitrust enforcement. They do not want to face private enforcers who are coming and bringing their cases into court. And I think one of the best things that we can do for antitrust enforcement is we ought to get rid of these forced arbitration clauses, and we ought to open up the courthouse doors for private citizens, and we ought to allow them to form class actions to do it. And we ought to do all of the above. I agree with you, Ms. Mekki, and Mr. Meador, we ought to empower your agency as well, because we need, I think you are fundamentally right, we need more law enforcement, antitrust enforcement rather, is law enforcement, and we need more of it. Just in my last remaining seconds here, Mr. Meador, let me come back to you. You've said that big is bad, which I completely agree with, and that we need to consider structural remedies. Is that true outside of the tech sector? I know you said that about tech. Is that true more broadly?
I believe the competition concerns that have been most recognized in the tech sector are common in many other sectors. We need to enforce the antitrust laws evenly across the entire economy.
Good. Let me just give you one example here. 4 companies currently control over 80% of beef processing in this country, and very similarly high shares of poultry and pork. In Missouri, just in the last year, we have had 2 poultry plants closed by the dominant poultry processor, Tyson Food, canceling contracts with farmers, putting hundreds of people out of work across my state, really acting with total impunity. Why? Because they can, because they are essentially a monopolist. Is this the kind of thing that the FTC could take action on?
Yes, with the small caveat that the Department of Justice typically handles the packers, but the FTC sees this at the retail level as well. When there are a smaller number of packers, retailers pay higher prices, and then consumers pay higher prices, and then retailers want to merge and consolidate their own part of the supply chain to counteract that, and then it's sort of an arms race to see who can get the biggest, the fastest.
I'll end with this. Right now, beef processing is just one example, but it's a perfect example for a state like mine. The only people who win are the monopolists. You know, if you're a cattle rancher, you're not getting paid for your product. If you are a consumer at the grocery store, you're paying an arm and a leg for some hamburger. And yet, so the consumers are paying more, the farmers are getting paid less. Who is really making out like a bandit here? It's the monopolists. It's the 4 people, the 4 companies that control 80% of beef processing. That is not competition. We need more competition in this country, economy-wide. Thank you, Mr. Chairman.
Mr. Chairman, I want to associate myself with those comments that Senator Hawley just made, but I also want to ask, can we please let the wonderfully wise and worthy workhorse Welsh go next?
Thank you. And I agree with Senator Hawley as well. You know, one of the issues that keeps coming up in Vermont, I talk to farmers and they want to repair their equipment and they can't. And if there's anything a farmer can do is fix things, and it's the way they save money and keep things going, and they can't take the time it takes to have somebody else come in and fix it. And they're not being allowed to do it. So a number of us think that there should be a right to repair. You buy the tractor, you should be able to repair it. And to some extent, technology is becoming a device by which the manufacturers control the market and control prices, but claiming it's intellectual property. But in fact, you bought the tractor, and if something goes wrong, why can't you, when you're somebody like a farmer who knows how to do things, fix it? So, Mr. Alford, I just want to ask you your view on, or pardon me, Mr. Meador, your view on right to repair.
Yes, I think it's incredibly important. And as you alluded to, the FTC has enforcement efforts in this exact area. I think it's critical that when a consumer buys a product, they can use their own labor or that of anyone capable to repair and maintain that product. I actually have a John Deere tractor myself, not the same one the farmers use, but I know how expensive it is to have that just maintained.
Well, I'll ask you, Mr. Alford. I brought, this is a car, but not a tractor, but I bring my car in to this place that is a mom and pop type of shop, and there's a lot of those in all of our communities, and they're telling me that it really costs them a lot to get the latest software to be able to fix whatever's wrong with my car, and it's leading folks to have to go to the dealership, which charges more. So it's bad for consumers, and it's bad for these mom and pop shops. Tell me your thoughts on this right to repair.
Yeah, Senator Hawley asked Mark Meador about a DOJ case, and you're asking me about an FTC case. But the answer to your question is yes. Right to repair is a critical argument that is important in antitrust enforcement. That is currently being litigated in the John Deere case at the FTC. There's significant case law on the right to repair as a legitimate antitrust argument. And so I think, yeah, that's definitely viable, and we're seeing more and more of that, as you say. There's sort of like these hermetically sealed boxes of hardware that it's incredibly difficult to open, and if you open them, you lose your warranty, and if you don't go to the official service and things like that. So there's lots of problems related to that. If I can respond briefly to Senator Hawley's question on agriculture, we absolutely agree that agriculture and antitrust are fundamentally important. The DOJ currently is pursuing a major agricultural case in agri-stats, but some of the other issues that were mentioned by my fellow panelists with respect to buyer power and the consolidation of all of the sort of upstream farmers being forced to sell to a very, very fewer and fewer numbers of buyers at the end is a huge antitrust issue, and so we're definitely focused on that as well.
And let me go back to Professor Mekki. Is it professor? You're at Berkeley?
I am at Berkeley, but I'm a senior fellow. But I'm honored for the recognition.
Well,
even if it's not deserved.
I went to Berkeley, so it's good to have you.
Thank you.
Hawley, get back here. We gotta defend Stanford, man.
No. Can you just describe how a federal right to repair would promote a more sustainable and competitive agricultural economy?
Absolutely. When I was the principal deputy and then acting assistant attorney general in the Antitrust Division, it was our mantra in the front office, don't mess with the farmers. And we took the view that when big, rapacious companies abused farmers, that they needed to be prepared to meet the Justice Department on the other side. And I think we saw that very clearly in the John Deere case, which is why in 2023, we filed in the name of the United States on behalf of farmers suing John Deere in the class action case. And so I think that a federal right to repair law would avoid the need for protracted, expensive litigation where experts come in and try to model harm to the fourth decimal point. There are just some things that come down to right and wrong. And I think that whether you're talking about the ability to repair your tractor or the expensive ecosystem of aftermarket parts and services, or really the I think most pernicious but least talked about issue in all of this is the sheer volume of data, farmers' data that is being fed back to John Deere and sort of used in the ways that big tech monopolies use user data is really quite concerning. And so I think this is a wonderful idea because we know what happens when companies pivot from being sort of an industrial monopolist to a sort of big data monopolist and then are charging expensive subscriptions and service fees in order for you to just interact with the product that you thought you bought.
Thank you. That's very helpful, and I like your advice. Don't mess with the farmers.
Don't mess with the farmers.
Thank you.
Thank you, Mr. Chairman. Mr. Bullard, forgive me that I had to run out on your testimony to go vote, but your written testimony is compelling, and I know your verbal testimony was. You've witnessed a lot of folks on your terrain here. Senator Hawley, I think, made me very happy as he echoed some of your points. I want to get a little deeper into it. Just ask you first about the Packers and Stockyard Act. Why isn't it, in your opinion, being enforced? And what might we do to make it have more teeth to prevent a lot of the harms that you so well detailed?
Well, I think it hasn't been enforced for the same reason we haven't enforced our antitrust laws, and that was a belief that if we just leave the markets alone, they will self-heal. Obviously, that has not happened, and it's decimated our industry. Congress recognized the need to provide additional protections to independent livestock producers clear back in 1921 when they passed the Packers and Stockyards Act. We now need the Packers and Stockyards Act to be fully implemented, and to do so, we need the U.S. Department of Agriculture to promulgate rules. And they began doing so in the last administration. They need to complete those rules. And that is because we have not enforced our antitrust laws. We have created an oligopolistic structure in the marketplace that is exerting harmful buying power upon the industry, and it is wiping out our producers. And if we don't take some immediate action in the form of regulatory relief, we will continue to see a loss of producers. And the Packers and Stockyards Act rules are the means by which we can provide some confidence to our industry and perhaps attract new entrants again if they believe they have a fair and robustly competitive industry to enter. So that's how we accomplish it. We write the rules and then enforce them.
I appreciate that, and I agree with you on the urgency for the Trump administration to finish that rulemaking process so we have some teeth. I want to switch to an issue that the good chairperson and I really bonded over. It's just the abuses within the checkoff program. We know that there needs to be serious reform. I'm proud to have introduced the Opportunities for Fairness in Farming Act, the OFF Act, with Chair Lee, which would reform that checkoff program. But can you explain what the beef checkoff program is and describe how it's been overtaken by lobbyists and lobbying groups and the interests of corporate meat packers over the individual farmers and ranchers, and how in many ways those programs are used to hurt you and your interests?
So the beef checkoff program was passed in the '85 Farm Bill. It was intended to provide monies for beef promotion and research, and the monies were collected in the form of taxes on independent producers, and it generates tens of millions of dollars a year. The intent, of course, was to increase demand for beef. However, the money's been funneled through organizations that lobby on public policy issues that are contrary to the interests of independent producers. So independent producers find themselves today being forced to pay a tax on every head of animal sold, only to see the funds from that tax being used in the halls of Washington to lobby against their interests. For example, our members fully support mandatory country of origin labeling for beef, and they found that the organizations that are major recipients of the beef checkoff program are lobbying in Washington against that interest. We shared then President Trump's, during his first terms, effort to withdraw from the Trans-Pacific Partnership Free Trade Agreement. However, the organizations that are checkoff funds were being funneled to were in fact trying to promote that failed trade agreement. So there are many issues like that that are where we see the interests of many cattle farmers and ranchers and sheep producers being undermined by the organizations that have received the funds.
Well, let's talk about that mandatory country of origin labeling. I honestly, again, I'm a guy from New Jersey. I didn't know about this before I came to Washington. I was sort of shocked at how we were screwing over independent ranchers with legislation like this. And so can you explain why mandatory country of origin labeling actually should be done right and it's not violated in the way that I've seen it violated, and why it's essential for fair competition, and really how did the elimination of this requirement in effect really harm American ranchers?
Well, in any competitive market, you have to have symmetry in information between the buyer and the seller. And currently, without country of origin labeling, the multinational meat packers that are importing beef from 20 different countries are able to bring it into the U.S. market and mask the origins of that product and actually pass it off to U.S. Consumers as if it were a domestic product because it bears the same U.S. inspection sticker as a domestic product does. But worse than that, since 2015, when country of origin labeling was repealed by Congress for beef and for pork, the current regulations have allowed meat packers to import a product, say a steak from Uruguay, that has a product of Uruguay label on it when it crosses U.S. Customs and Border Protection. And then when it's brought into a U.S. processing plant, the Uruguayan label can be thrown in the garbage, a new plastic wrapper fixed around the meat, and then it can be sold with a product of the USA label. Now, USDA did go through a rulemaking process, and on January 1 of 2026, we're supposed to see that remedied. However, that's only a voluntary law, so it is not going to require any packer to label any foreign products, and we are seeing a significant increase in the volume of foreign beef coming into this country, being passed off to unsuspecting consumers as if it were a domestic market product, and as a result, they're priced accordingly. Instead of the consumer receiving a discount if the product is half the cost from Uruguay or Argentina, for example, consumers paying the same price as if it were domestic. So consumers are being deceived, they're being exploited in the marketplace without mandatory country of origin labeling. Consumers deserve to know where the beef came from and under what country's food safety production regime it was produced under.
Mr. Chairman, I hope we do another round, but I'm going to stop here in deference to my Alabama ancestors and my dear friend, the Senator from Alabama.
Thank you very much. I just ran the length of Russell, so thank you for giving me a moment to catch my breath. Mr. Chairman, I really appreciate you holding this hearing today and certainly believe it is critically important that we talk directly about the fact that government overreach and overburdensome regulation contributes to higher prices for Americans and often worse outcomes. After 4 years of the previous administration, it is refreshing to see President Trump committed to ensuring that American companies are able to innovate free from undue government intervention. Deregulation of many industries, it drives innovation. I believe it lowers cost. It ensures that the market and not the government is actually picking winners and losers. And so I'm going to start with Commissioner Meador. I want to address you with my first question. I know President Trump has instructed the FTC to investigate what anti-competitive regulations are actually undermining entrepreneurship and innovation here in America, and how both the administration and Congress can work together to actually unleash the American economy. So can you give us an update on that and let us know kind of what steps are being taken as a result of that executive order and how those efforts are going to ultimately help us have better outcomes and lower prices?
Yes, Senator, of course, thank you. So the process is ongoing. FTC and DOJ have both received a large number of comments from people across the economy and across the country highlighting regulations that they believe are harming competition, that are preventing small businesses from entering and disrupting static markets. So we are actively reviewing those. One of the benefits I think both the Antitrust Division and the FTC bring is our vast experience enforcing the antitrust laws. And this is what we do on a daily basis, is evaluate how competition works in these markets. And so that's going to enable us to review these regulations to see how they might be unintentionally or unfortunately sometimes intentionally distorting competition in those markets. And then we can inform the agencies with recommendations to say, we think these regulations are problematic. Here are ways you might consider modifying or perhaps rescind them. But then we can also provide guidance to Congress so that you as the legislative body can take steps to remedy them if necessary.
Thank you. So one of the things I want to talk to the whole panel about is healthcare cost. So when you look at those continue to skyrocket across our nation, whether it is PBM, scope of practice, generic drug manufacturing reforms. Americans are tired of paying more and getting less. And when it comes to healthcare, it is my belief that Americans deserve better. In my view, a massive part of the problem of our healthcare system is that the government refuses to get out of the way and let our healthcare providers adapt to ways to better serve their patients. And time again, again. I feel like the data shows that when the government deregulates various industries, innovation skyrockets, and we do have better outcomes. So if we could just quickly go down the panel, what government regulation do you see that you believe contributes most to poor outcomes in our healthcare system, and what reforms could Congress adapt to ensure that our patients can receive and providers can actually provide quality, affordable care, particularly in rural and underserved communities? So we'll start with you and then just head down.
I think you're exactly right to put the spotlight right on healthcare as a space where both private and government interventions are reducing output, driving up prices, lowering quality, and really harming patients and those who pay for care through their insurance premiums. Here are a couple of highlights. Thing number one, across the country, in something like 2/3 of states, certificate of need laws require federal bureaucratic permission before a hospital or a healthcare provider can enter the market or expand. For decades, under both parties, the FTC and DOJ have been screaming about how these laws demonstrably drive up prices, lower quality, harm patients in exactly the way that you're describing. Worse still, they were popularized by a federal congressional mandate in 1974. It's time to put that engine in reverse and incentivize repeal of certificate of need laws. Number two, certificate of public advantage laws. Congress owns and controls the federal antitrust statute, but the Supreme Court has given for decades state governments the power to immunize private mergers, including hospital mergers to monopoly. These certificates of public advantage, time and time again, work demonstrable harm on patients' access to healthcare and the prices they pay for it. Congress should close
Professor Francis, I am so sorry, but I am almost out of time. So if we can quickly get to your third, so that we will have to do like a lightning round if the chairman is so gracious to allow that.
I can hit the third in one sentence. Right now, if you're a branded drug owner, you can throw a patent in the Orange Book without any review from the USPTO. We should let the PTO check that's not being abused.
Thank you. Was it my running here that gets me this additional time?
Listen, we've been playing fast and loose all afternoon.
They're going to give you all my time, so go ahead.
A bunch of us have planned for that 4 p.m. briefing this year, which apparently has been canceled, so we got more time.
Thank you so much, Mr. Chairman.
And I'll defer to my fellow panelists, but I'd like to come back if there's still time. But I'll let those with expertise in this area answer you.
So as Commissioner Meador mentioned, the deregulation task force at the FTC and the DOJ are focusing on a whole variety of different healthcare issues. The comments, over 400 comments that have come in, almost half of them have been related to healthcare concerns about regulatory burdens associated with that. And that includes not only at the federal level, but also at the state level. So Professor Francis has been talking about certificate of needs at the state level. Mm-hmm. There are a lot of problems at the federal level as well, and a lot of the comments have come in related to that. So, lower cost treatment options, like nurse practitioners and nurse anesthesiologists, there's restrictions on that. Rules that prevent physicians from owning medical facilities, site of care restrictions, the whole variety of things. And so as part of this executive order, we're collecting all of that suggestion, and then we're trying to prioritize the ones that we think are most likely to be the most beneficial to the average American consumer, and then we're going to be working with cooperative agencies to try to see if we can revise some of these regulations. So that's basically the answer that I would say at the federal level.
Thank you so much, Mr. Alford.
Senator, thank you for asking the single most important question in antitrust right now, which is what to do about healthcare. There is no bigger cyclone and convergence of private regulation by monopolies, bad public regulation, and the platformization of healthcare after years of unchecked mergers and serial acquisitions in this space. And so this is a time not to focus on sort of ticky-tacky sort of process deregulation, but to rethink the whole regime because the problem is so bad. I was alarmed to read a report recently that in Connecticut, I believe, there was a national security brief that described the healthcare crisis as a domestic security crisis. And so here we can do things like what we did in the Biden administration, which is make hearing aids available without prescriptions, and to our friends at the FTC sent warning letters to pharmaceutical companies to bring down the cost of inhalers and things like that. But here, I mean, legislation has hastened vertical consolidation that allows, and again, this is well-intended regulation. It's Obamacare. It's the most substantial piece of legislation we've had in healthcare in a long time, and it does many good things, but there's also some hidden pathologies, right? Circumvention of the medical loss ratio, the ability of the biggest behemoths to essentially pay themselves. And so my former boss, Jonathan Cantor, was really fond of saying, back then, when people said single payer, we all thought we were talking about the government as single payer, but pretty soon we're going to have maybe a different kind of single payer system, right? Living under the tyranny of a very big health insurance giant that seems to own everything.
Mr. Chairman, I just want to lodge a complaint that the Democratic witness said the best question of the day was asked by a Republican senator. I mean, that is something that just should not be tolerated.
Fair enough. Fair enough.
Thank you, Senator. I would echo the comments of my fellow panelists and just add that there's a role for the FTC to continue to play in enforcing the antitrust laws in the healthcare space, especially around regulatory evasion and manipulation. I think there's a lot to address in that.
Well, guys, I appreciate it more than you know.
Senator, I'd like to comment and get as close to the mark as I can from the cattle and sheep industry's perspective. But the United States has always held a standard that foreign meatpacking plants in foreign countries had to meet the identical health and safety standards as we do in the United States. However, after we entered the World Trade Organization, first thing we did was relax the standard requiring foreign countries to have food safety standards at least equal to the United States. We relaxed it to where now the standard is close enough. And as a result, these foreign countries need only have standards equivalent to the United States. That's why when we say the beef in the United States is the best beef in the world produced under the best of conditions, we can prove it, and that deregulation of the regulation that once protected consumers is non-existent. Recall in 2017, we had to close the border to Brazilian beef because they were sending tainted beef around the world. So there's a food safety issue that affects America's health, and I just wanted to add that. Thank you.
Thank you, Mr. Chairman. Thank you, and Mr. Vice Chairman. Thank you for your kind words there.
He prefers to be called Viceroy, but anyway, that's just him. Senator Klobuchar.
Thank you, and thank you for your words on public health from the ag perspective as well, Mr. Bullard. As you know, I do a lot with ag over in the Agriculture Committee, which Senator Booker is part of as well, and thank you for being here. I did want to take off on the healthcare question first, and thank you for your comments, Ms. Mekki, and just specifically on pharmaceuticals. As you know, we've done a lot of work in this committee with Senator Grassley and others on the pay-for-delay bill that he and I have long sponsored, and we've had other legislation with a number of people on this committee to stop some sham practices. But one way there's been an abuse of rules is blocking competition, is listing many patents on the FDA Orange Book that shouldn't be there to deter competition. The last administration issued warning letters about this practice, leading a number of drug companies to remove patents and lower prices. The Trump administration has continued this policy. Could you talk about how can antitrust enforcement deter this anti-competitive abuse of the Orange Book? And is it really orange? And could you describe what this is? Because it sounds kind of scary.
Senator, I am thrilled that you're putting a spotlight on this. As you well know, the antitrust laws have really struggled in the pharmaceutical space to, catch on a whack-a-mole kind of way practices that those with market or monopoly power are using to harm consumers in our most important markets. You're exactly right as well that there's a specific practice that's starting to get a lot of attention. When you get a new drug approved by the FDA, you tell the FDA which patents read on the drug or a relevant method of using it. That is produced in a document that only historically, I think, I'm not a pharma expert, but only historically was a physical document with an orange cover. These days it's a government database. And once that's listed, if you want to come along with a new drug, you certify to the FDA on an individual basis why each of those patents that are listed have expired, are invalid, or not infringed. And when you do that, there's a stay of about 30 months that's triggered on your application to get into the market and compete as a generic. So a manufacturer has every incentive to overlist patents that really aren't pertinent to the drug, its composition or formulation, its method of use, because it deters generic entry. There are two things that we could concretely do. Number one, to the extent that that is being done intentionally with an intention to deceive by a monopolist, that's a Section 2 violation. It's illegal monopolization, and our antitrust enforcers can take action. But that's kind of an expensive and cumbersome way to get at the problem. Two law professors, Scott Hemphill at NYU and Bhavan Sampat at Arizona State, have recently suggested we should have the US Patent and Trademark Office, for any patent that's newly listed in the Orange Book, take a look at it. Make sure that it's valid, make sure that it's pertinent to the drug. I think that's a terrific idea. It'll help catch abusers and monopolists, and it'll protect patients.
Okay, very good. You want to add anything, Commissioner, to that?
I just think those are great ideas. In addition to the ongoing enforcement efforts, and as Professor Francis pointed out, we have an active role to play here, and we are taking a close look at it.
I've appreciated how you've supported funding of the agencies and the like, so congratulations. Big tech, do you think I was going to bring it up, Mr. Alford? Congress, still we have yet to enact common sense rules of the road, although Senator Lee and I worked together on the allowing state AGs, his bill, to keep the cases where they were brought. And also we've done something on merger fees that was temporarily set back, but I will say the newest budget from the administration allowed those merger fees to be charged. This is under the ongoing CR. There's a limit on them. And those merger fees, while they're collected, should be going to antitrust, as you know. So platforms have turned into their own unaccountable regulators. Apple sets the rules for app developers, including an onerous 30% private tax, the subject of a bill that Senator Blumenthal and Senator Blackburn and I and others have taken on. Amazon does the same for independent business selling products online. Google and Facebook control much of what we see online and the advertising dollars that flow from it. Mr. Alford, in your testimony, you said that the Antitrust Division's mission is to stop cartels and monopolists from exploiting their power to act as governors of their industries. I like that. That's good. What role does antitrust law play in protecting consumers, workers, small businesses from this arbitrary regulation?
Thank you for the question. Just a 1-second caveat on the pharmaceutical question. On June 30th, the Department of Justice and the Federal Trade Commission is having a listening session on drug pricing pursuant to the EOs on drug pricing.
Very good.
To answer your question on, thank you for the legislation that Senator Lee and Senator Klobuchar sponsored with respect to the budget and the fees and the merger fees going to the Department of Justice. It's incredibly helpful, and we're very encouraged by the fact that the Trump administration budget has encouraged the payment of those merger filing fees to the DOJ. With respect to platforms and the private moats that they are creating, I think that one of the goals of monopoly abuse is to basically capture the entire universe of the market action that happens within those platforms, so that there is essentially no real freedom of mobility for consumers and no viable entry for other competitors. We are seeing that over and over again, and most of the cases that have been brought by the DOJ relate to the kind of monopoly abuse in which there are extraordinarily high barriers to entry and in which there is no meaningful choice by publishers and advertisers in either search or in ad tech. So that is what we're seeing. There is not the migration to alternatives because of the fact that they have their entire say. And of course, I should also add that the private litigation in Epic Games is also related to the kind of things you're talking about as well, and the sort of tax on the apps. And that's also being addressed as well. So all of those kinds of litigations are addressing those concerns.
Ms. Mekki, as we look at why we haven't put any rules of the road in place, one of the things is these tech-funded groups have spent loads of money. They spent hundreds and hundreds of $1 million against the bill that Senator Grassley and I introduced, and I appreciated Senator Booker supporting that bill, and that's the American Innovation and Choice Act. And it passed through this committee, but then a whole lot of lobbying took place. How do dominant companies use their power to influence the government to enact rules that protect their market position and stop us from seemingly putting any rules of the road in place?
I think people of all stripes agree that we need competition, and big tech is a theater that brings together a lot of people across the political continuum who are worried about competition in these markets. What I find so interesting about the tech companies is that they really resisted antitrust for a very long time and thought that was too radical, and instead said, well, we'd like regulation, but wait, not that regulation. And so in the backdrop of all of that.
And they said, let the states do it, but now they're like, no, don't let the states do it.
Anybody but the states, right? But in the backdrop of that, the agencies have been litigating big, sweeping monopolization cases. Yes. And so far have been winning, whether it's the Google search case or the Google ad tech case. We have the Meta trial that our friends at the FTC just concluded, and we'll see what the outcome of that case is. But I think that courts are making findings that really support the underlying foundation of the legislation. And so, you compare the tens of millions of dollars that the agencies had to expend just on expert fees to litigate those cases to get to outcomes that the legislation likely would have also helped us get to.
That's what I've said this many times in this very room, that if they'd work with us on some reasonable rules, we wouldn't have been where they are right now, which is two very different administrations pursuing the same cases, which is usually a sign of success if you look at AT&T and other cases from the past when it bridged political parties. Last question, Mr. Meador. The FTC enacted a number of pro-competitive rules over the last few years. They required upfront pricing to make it easier for consumers to compare prices for concert tickets, for hotel rooms. I am working to codify these changes into law, and including we have a hotel bill that passed the House that just has wide, broad support. There's one senator that doesn't like it very much, so I'm trying to find a way around that. And it's not Senator Lee. Your colleague, Commissioner Holyoke, said she supported the rule because hidden fees undermine the ability of honest businesses to compete on price. Do you agree, and will you commit to enforcing these rules?
To answer the last part, of course, yes, the FTC stands ready to enforce all of the policies that Congress sets out for us. And I agree, it is critically important that consumers have transparency and a clear sense of what price they're paying in order to have free and fair competition in the marketplace.
And interestingly enough, on the hotel bill, we worked with the industry to come up with something so that we could police some of the bad actions that were going on, but they felt it was in their best interest. So did the House, and we're almost there, I think. So, but thank you for your work. Thanks, everyone.
Okay, so we'd like to start a second round, and I'm going to let Senator Booker go first.
This whole hearing has been chaos, Democrats and Republicans working together and being generous and magnanimous. This can't stand in Washington right now. But I do have two quick questions. Unfortunately, I have to run, and I'm going to yield back to the chairperson. And Ms. Mekki, they're both for you, if you don't mind. So the first is just going back to Mr. Bullard's points about the Stalkers and Packyard Act. I just really want to drive down, and he was saying very pointedly that there's some rulemaking processes going on now that would be a lot more efficient. Now, you helped bring the first Packers and Stockyard Act case the agency had brought in years. This was a lawsuit against the fifth largest poultry processor. We've heard from Josh Hawley about what's happened to the chicken industry in the United States, which is this massive consolidating going on, exercises of power that I found stunning and hurting poultry. In fact, I often think that what they're trying to do to the cattle industry is what they've already done to the poultry industry. How can the enforcement of the Packers and Stockyard Act protect farmers, ranchers, and cattlemen against what's happening in big ag right now, and in turn, I think your points earlier about consumer freedom, how could it help lower prices for consumers, in your opinion?
The Packers and Stockyards Act is a gold standard piece of legislation that actually was passed after the Sherman Act. and largely because Congress saw what the courts had done to interpretation of the Sherman Act and unduly narrowed it, and so gave the ranchers and farmers essentially a law that looks a lot like Section 5 of the FTC Act, which prohibits unfair methods of competition and certain so-called UDAP violations. And even then, you saw courts interpreting the Packers and Stockyards Act in ways that were unduly narrow. And so we did two things when we saw evidence that two chicken processors had really behaved in a borderline tyrannical manner in something called the tournament system, where chicken growers are kind of subject to these arbitrary rules and the whims of processors, even though they really have very little control over the yields that the chickens that they grow ultimately bear out in the market. And so we did two things. We looked out and we saw the Packers and Stockyards Act and reprised the role of the Justice Department as the lawyers for the executive branch, and had that delegation, that authority delegated over to us so that we could bring the first Packers and Stockyards Act case for the first time in recent memory, maybe ever. We could not find an example of the Antitrust Division bringing a Packers and Stockyards Act case. The second thing that we did, and I should say my former deputy, Michael Cadis, I think is in the hearing room and did extraordinary work with the USDA to start working on rules under the Packers and Stockyards Act to bring fairness to these markets. And so it is my hope that the Trump administration will continue that work and that effort to, again, just bring free markets and fair dealing to chicken growers and all of the other kinds of growers and ranchers that will benefit from that kind of rulemaking.
So Abraham Lincoln said, too much agreement kills a conversation. So let me insinuate some partisan nature of this conversation. But in all seriousness, Democrat and Republican presidents have failed, in my opinion, to bring aggressive enforcement to the level that we need to deal with the large corporate concentration that's from the healthcare industry, from farms to pharma, let's put it that way. But I am concerned that we have an administration right now, and I agree with Mr. Alford's quoted in his testimony, the alliance between big business and big government must be broken. I have a lot of concerns right now with the president's alliance with certain big businesses, specifically Elon Musk. Is this kind of corporate connectivity, in your opinion, hurting average Americans?
I think that the president's decision to bring in the richest man on planet Earth and give him what appears to be unfettered access to our federal agencies, our most sensitive, intimate financial data, and other kinds of information about the American people, really is a playground for potential malfeasance. And I think we started to see that as soon as Inauguration Day, where you saw the richest people on planet Earth in the Capitol Rotunda warm, and the people who helped put Mr. Trump in office were outside, cold, unable to see what happened. And so it sends a message about who the president is for. And I think the antitrust agencies deserve to sort of rise and fall in their own merits and based on the decisions that they make with the authority that's entrusted to them. And I think that there are some examples of really good work there. There are other parts of the administration that really give me a lot of anxiety and a lot of pause about the incredible power that we've entrusted to the executive branch. And so whether it's Mr. Musk's ambitions in space, whether it's his ambitions in potential payment platforms, they're sort of the recipe for conduct that could really hurt people, and I think it deserves very close scrutiny.
So I just want to give one more note of gratitude to the witnesses and to the grace of my colleague for allowing me to get my questions in really quickly. I'm going to leave, therefore I surrender any check and balance to this hearing whatsoever. I just want to remind him that I did abuse my power when he left, but two wrongs do not make a right. Thank you, everybody.
Thanks so much, Senator Booker. It really is immense trust and confidence that he's placed in with this. I mean, for all he knows, I could spend the whole afternoon talking about the Dormant Commerce Clause now, but we won't put everybody through that. There are a few follow-ups I want to answer. Mr. Bullard, you mentioned the benefits of the OFF Act, and I appreciate your support for that in your comments. How, in your view, has USDA oversight failed to oversee the checkoff programs adequately, resulting in some of these problems in the programs?
Yeah, so historically, it's been a hands-off approach by the U.S. Department of Agriculture. A private consultant found in 2010 that there were about $200 and some thousand were misappropriated out of the checkoff funds. Soon thereafter, the OIG did an investigation and completely ignored that malfeasance. And upon our complaints, they redid their report and suddenly they made mention of it. But so the U.S. Department of Agriculture was asked for many years to separate the organization that's the major recipient of the beef checkoff program, to separate what the subgroups they had within their organization that they claimed to have a firewall between. But and that's the Federation of State Beef Councils that's housed within the National Cattlemen's Beef Association. But no action has ever been taken. So even though the USDA was well aware of the problems, no action was taken. We ultimately filed a lawsuit alleging that the lack of oversight on the part of USDA constituted a unlawful subsidy, a violation of the Constitution, where producers were compelled to fund the private speech of private entities. And through the course of that litigation, USDA did make some reforms, but they are inadequate to protect the producers against the ongoing assessment against them, the tax, that still funds policy initiatives that are contrary to their interest. Funds by way of lobbying, providing organizations the ability to lobby.
I remember Robin Williams joking about the unarmed English Bobby, who upon seeing the commission of a crime would shout, "Stop," or I'll yell, "Stop again," because he's unarmed. Is that sort of what you're describing here, is that maybe they're aware of problems, they're not enforcing them, and they just go unenforced?
That's very possible. There appeared to have been no will whatsoever to enforce the act.
Ms. Mekki, let's go to you for a moment. You noted that nearly 1 in 4 public comments identified healthcare competition concerns. And I don't doubt that at all. I mean, just knowing how people feel about those issues generally, and knowing what we've seen has happened with consolidation in that industry and what has happened as a result, it ends up being problems. What specific actions do you think might be most helpful in ameliorating this problem and addressing the issue of excessive consolidation within that industry?
So there are things that I can't talk about publicly based on work that I did when I was at DOJ, but I will say that I hope and trust that the Justice Department's Antitrust Division is focused on enforcement against some of the private regulation side of the ledger. There are also myriad regulations that Congress and the agencies could work together to address, right? There are kind of arbitrary rules, including things like the ability of the federal government to negotiate drug prices with drug companies for Medicare and Medicaid that, to me, seem extraordinary. And I know there have been some gains with recent legislation, but this is a market that government itself has created and funded, and the ability to, the fact of not being able to negotiate prices fully is really extraordinary to me. Even in the face of prior authorizations and distant, faceless, sometimes nameless personnel who decide whether a doctor's decisions to, prescribe certain medications or recommend certain courses of care they can veto that, right? And even when Americans are facing those kinds of circumstances with their health insurers, they're not allowed to switch their health insurance except for once a year, right, for most people. And so that, again, that is an example, that is regulation too. And there's an arbitrariness to it that deprives consumers of choice and really tilts markets in favor of health insurance companies. I think there are myriad examples like that, but there is a structural problem with our healthcare markets. I had the pleasure of doing both civil and criminal enforcement when I was at DOJ, and there are sort of hallmarks of different kinds of frauds and schemes that you sort of see built into the structure of our healthcare system, right? There's opacity, there's tremendous distance between who's paying and who's receiving services. And all of those characteristics make me worry hugely that we don't actually have a real conception of the cost of delivery of care such that we can get in and make things better. And if you'll indulge me, I have to say, I was listening to a guy named Michael Zembalist recently, and he's, I think, like the top investment officer at JP Morgan. So this is someone who sits on investment committees and has to make decisions about the allocation of securities and assets for pensions and foundations and funds of all types. And he was asked, what is the market that he has the most trouble cracking? And he said healthcare, right? And this is someone who's figured out, keys to unlocking the energy crisis as we see an explosion in AI services in the product ecosystem, who's really taken a close look at big tech and other markets that are quite difficult sometimes to navigate. But healthcare is the one that is the most opaque and mysterious, even for someone whose full-time job it is to understand markets and make money for a very large bank.
Can I just have a quick comment on that? Because we inherited some of the healthcare cases that she is referring to. Right. And so I just want to say that at the Department of Justice, Attorney General AAG Slater has healthcare antitrust enforcement as her top priority. It is an absolutely critical aspect of the work, and we talk about it every single week. And so we really are at an inflection point for a variety of reasons. We have an executive order on deregulation in which the other agencies are mandated to cooperate with us on anti-competitive regulations, and we're working actively with other agencies in the healthcare space. We also have separate EEOs on drug prices and ordering that we address drug pricing crisis and that mandate. And then we have years of investigative work that has been done at the DOJ prior to our arrival, in which we can then pick up that mantle and try to look at what are the appropriate antitrust arguments on the litigation side. And imagine the excitement that the DOJ antitrust lawyers felt when they won the Google case and then won the next Google case. Imagine the same kind of excitement that we'll be having when we successfully win a healthcare case like that and successfully get regulatory reform to address some of the healthcare crisis. That's what we're looking at.
Thank you. Both of your answers are very helpful. And Ms. Mekki, I loved your description of, hadn't quite thought through to that extent. You're describing essentially switching costs. And switching costs made more complicated by virtue of the narrow time window in which Americans, particularly on an employer-sponsored plan, but really on most plans, have to make a decision more or less annually. And if it is an employer-sponsored plan, as is often the case, they'll also be somewhat limited based on which plans their employer is willing to consider. And with the Byzantine labyrinth of federal regulatory requirements that they have to comply with in order to do it, that itself probably interferes with their ability to disrupt the marketplace through more innovative plans. Is that a fair characterization of some of what you've said?
That is certainly one flavor of the problem. There's also just, going up a level, most people really struggle to shop for healthcare. It is so complex. And again, if you're a new health plan and you're operating in, as you noted, the labyrinth of different requirements, whether imposed by the federal government or a state government or the private monopolies, you are essentially having to take little nibbles as opposed to doing big, sweeping, innovative, great things that the American people, all else being equal, may well prefer to the existing plans.
Right. No, that's a great point. And some of those monopolies, or there's been consolidation in the industry. That consolidation has led to a smaller number of major players having a significant sort of dominant control over that industry, in part because the regulatory nature of things will tend inevitably to make it easier for a startup, a new competitor, to come onto the scene. Yeah, that's an entrenched problem. Mr. Meador, after sifting through the 400 comments or so, what are your insights on this and where we ought to go with it?
As I mentioned in my opening remarks, I think the key insight is that we are seeing a similar perspective across multiple different parts of the American economy. Individuals, small businesses, organizations that represent multiple businesses are all pointing out that many of our regulations do seem tilted in favor of large incumbents. They prevent entry. They're frustrating consumers getting the outcomes that they're looking for. And so I think this is a target-rich environment, both for antitrust enforcers, for regulatory agencies, and for Congress to step in and fix the problem to make sure that our regulatory system and our law enforcement efforts all work to the benefit of American consumers.
Great. Mr. Alford, I want to go back to what you were talking about a minute ago. Given the wide variety of state-level regulations, from rent control regimes to livestock inspection requirements, how does the Antitrust Division plan to coordinate with state attorneys general and legislatures in order to identify and roll back some of the more burdensome and anti-competitive restrictions?
Yeah, it's a great question. So as you look at the sort of deregulation projects that one can envision, you have a four-box matrix. You have federal laws, you have federal regulations, you have state laws, and you have state regulations. And we've been speaking to a large extent about federal regulations and working with other federal agencies, but Professor Francis identified some of the most important issues are with respect to state laws. And so in that respect, I think there's a variety of things that could happen. He's already referenced the Dormant Commerce Clause. You've referenced the Dormant Commerce Clause. In the first Trump administration, we did use the Dormant Commerce Clause as an antitrust tool as a possibility. We also routinely engage in advocacy at the state level to try to address concerns, typically in the context of encouraging the enactment of laws that are pro-competitive rather than anti-competitive. But I do think you're right that we do need to talk with the state AGs and with the state legislatures to see if we can make the case for a modification of some of those state laws. And then the final option that I think Professor Francis mentioned is there a role for Congress to try to deal with things that would create the preemption that you need to deal with truly anti-competitive regulations? And it's not just about healthcare, as you said, it's agriculture, it's housing, it's franchise dealer laws. There's a whole variety of different examples of state laws that are problematic.
All right, let me make sure that that covers it. I think we're good. Anything else? All right, really appreciate you being here. All five of you have contributed very meaningfully to this conversation. It's been really helpful. Questions for the record will be due 1 week from today at 5 p.m. and the subcommittee stands adjourned.